Hi, it's Christina with the Sisyphean Journal, and today I'm responding to a video. It's a news story that was posted yesterday talking about a district attorney who invokes the Fifth, refusing to answer questions about whether she was involved in witness intimidation in a Walmart shooting that took place a couple years ago. And I am not in any way trying to detract from the extremely legitimate outrage over this. Okay, this was completely out of line. She has a responsibility to the public. She has a responsibility to the victims. It was completely inexcusable what she did. But you want to be outraged over public officials abjectly failing in their duties. You need to look no further than the Kermit Gosnell grand jury report. Now, for those of you who aren't familiar with the Kermit Gosnell case, this guy ran an abortion clinic in Philadelphia that barely achieved bus station men's room. Well, no, didn't even achieve bus station men's room levels of cleanliness. There were flea-infested cats roaming around, crapping on the floors. The women were wrapped in blood-stained blankets that staff washed once a week if they got around to it. Nobody knew how to do CPR. Most of the staff weren't even high school graduates. They were doping these women within inches of their lives when there wasn't even a doctor on the premises. They were using an anesthesia chart drawn up by a 15-year-old girl who had had about 20 minutes of training. And it was routine there to perform third trimester abortions by delivering the babies alive and then severing their spines with surgical scissors. So one of the things that the grand jury that finally got the case dumped on them was, how did this go on so long? And there were numerous people who dropped the ball, but right now I'm going to look at the Department of Health. Those were the people that were responsible for the clinic itself. The Department of State is the medical board. They were responsible for Gosnell. This is the Department of Health that was supposed to inspect abortion clinics annually and not give them licenses if they weren't safe places and if they weren't following the law. And if you follow the link to the companion post, I do provide the sections of the grand jury report relevant to this. I'm providing a link to the grand jury report itself, and I went through and I highlighted the parts that I'm going to go over today, where you can look at, they didn't just drop the ball, they threw it away. So what I say here is going to be quoted verbatim from the grand jury report. We discovered that Pennsylvania's Department of Health has deliberately chosen not to enforce laws that should afford patients at abortion clinics the same safeguards and insurances of quality health care as patients from other medical service providers. The department has shown an utter disregard for both the safety of women who seek treatment at abortion clinics and for the health of fetuses after they have become viable. The Department of Health's neglect of abortion patient safety and of Pennsylvania's laws is clearly not inadvertent. It is by design. State health officials knew that Gosnell and his clinic were offering unacceptable medical care to women and girls, yet DOH failed to take any action to stop the atrocities documented by this grand jury. These officials were far more protective of themselves when they testified before the grand jury. Even DOH lawyers, including chief counsel, brought private attorneys with them, presumably at government expense. Gosnell's clinic, with its untrained staff, its unsanitary conditions and practices, its perilously lax anesthesia protocols, and its willingness to perform late-term abortions for exorbitant amounts of cash, and its routine procedure of killing babies after they were delivered by their unconscious mothers, offers a telling example of how horrendous a Pennsylvania facility can be and still operate with DOH approval. The Department of Health conducted sporadic, inadequate inspections for 13 years and then none at all between 1993 and 2010. Pennsylvania's Abortion Control Act charges DOH with regulating and overseeing the performance of abortions and the facilities where abortions are performed, and they're quoting the law, so as to protect the health and safety of women having abortions and of premature babies aborted alive. Even though the first DOH certificate of approval for Gosnell's clinic expired on December 20th, 1980, the next documented site review was not conducted until August 1989. By 1989, Gosnell, who was not board certified as either an obstetrician or a gynecologist, was the only doctor at the facility. There were no nurses working at the clinic. Blood work was no longer sent out to an independent lab, but was done, supposedly, by medical assistants. And in 7 of the 30 patient files reviewed, there was no lab work recorded. There were no board-certified doctors on staff or contracted as a consultant, no nurses overseeing the recovery of patients, no transfer agreement with a hospital for emergency care, and no lab work recorded in several files. Even so, based on promises, the DOH site reviewers recommended approval of Gosnell's clinic for another 12 months. 2.5 years later, in March 1992, when DOH representatives next inspected the clinic, there were still no nurses to monitor patient recovery. They did indicate that there was adequate access for stretchers and wheelchairs, though it is not clear how they reached this conclusion. The facility is multi-level and had no elevators. There is nothing to suggest that these evaluators reviewed any patient files. DOH inspectors left blank the section in their report on anesthesia, including who is permitted to give it, what their qualifications are, and the type of anesthesia they are permitted to administer. Evaluators inexplicably concluded on March 12, 1992 that there were no deficiencies, and DOH approved Gosnell's clinic to continue to perform abortions. The next inspection was conducted on April 8, 1993. This was also the last site review until February 2010, when an inspection occurred because law enforcement executed search warrants for illegal drug activity. The 1993 site review did not include any first-hand observations about the cleanliness of the facility or the condition of the emergency equipment required for resuscitation. Instead of making their own inspection, the evaluators appeared to have relied on representations by staff about procedures for cleaning and checking equipment. On July 23, 1993, without a follow-up inspection, Susan Mitchell recorded that the deficiencies had been corrected. DOH sent Gosnell another certificate of approval. During the next 16-plus years, as Gosnell replaced his few licensed medical assistants with untrained workers and a high school student, as his outdated equipment rusted and broke and he routinely reused instruments designed for single use, as he allowed unqualified staff to administer anesthesia and to deal with babies born before he arrived at work for the day, and as he caused the deaths of at least 2 patients while continuing to perform illegal third trimester abortions and to kill babies outside their mother's womb, DOH never conducted another on-site inspection at the Lancaster Avenue facility. According to DOH witnesses, sometime after 1993, DOH instituted a policy of inspecting abortion clinics only when there was a complaint. In fact, as this grand jury's investigation made clear, the department did not even do that. In January 2002, an attorney representing Shamika Shaw, a 22-year-old woman who had died following an abortion at Gosnell's clinic, wrote to Stolowski requesting copies of inspection reports for any on-site inspections of the clinic conducted by DOH. Stolowski wrote to the attorney that no inspection had been conducted since 1993 because DOH had received no complaints about the clinic in that time, except that it had. In 1996, another attorney representing a different patient of Gosnell's informed Stolowski's predecessor as director of the Home Health Division that his client had suffered a perforated uterus requiring a radical hysterectomy as a result of Gosnell's negligence. No document in the records turned over to the grand jury, not documented in the records turned over to the grand jury, was a second complaint registered between 1996 and 1997. This one was hand-delivered to the Secretary of Health's administrative assistant by Dr. Donald Schwartz. Dr. Schwartz, a pediatrician, treated teenage girls from the West Philadelphia community. Occasionally, he referred patients who wanted to terminate their pregnancies to abortion providers. He and his physician partners noticed, however, that patients who had abortions at Women's Medical Society were returning to their private practice soon after, infected with trichomoniasis, a sexually transmitted parasite that they did not have before the abortion. Dr. Schwartz told the grand jury that he does not know what happened to his complaint. We know that no inspection resulted. We also do not understand how a report of this magnitude was not at least added to Gosnell's file at the State Department of Health. It suggests to us that there may have been many more complaints that were never turned over to the grand jury. In addition to these two complaints filed in 1996 and 1997, Stolosky herself received 2 inquiries from attorneys' offices about Gosnell's clinic in the first 2 months of 2002. Yet she ordered no investigation of the clinic, even though it had not been site reviewed in 9 years. In 2007, Dr. Frederick Hellman, the medical examiner for Delaware County, that's Philadelphia, reported to DOH the stillbirth of a 30-week baby girl. A medical examiner investigator, Irene LaFleur, made phone calls. She spoke to several DOH employees, including Brody, the senior counsel. The investigator reported to the DOH officials that the medical examiner had conducted an autopsy on the stillborn baby delivered by a 14-year-old girl at Crozier Chester Medical Center. She explained that the baby's delivery had been induced in the course of an abortion performed by Gosnell, and that the medical examiner was concerned because performing abortions at 30 weeks was a clear violation of the Abortion Control Act. Brody suggested that the medical examiner informed the district attorney's office in Delaware County. Brody said that neither DOH nor the state medical board had authority over the matter. The department should have initiated an investigation. DOH could have revoked the clinic's license without waiting for a criminal prosecution that might never and did not happen. Stokosky blamed the decision to abandon supposedly annual inspections of abortion clinics on DOH lawyers, who, she said, changed their legal opinions and advice to suit the policy preferences of different governors. Under Governor Robert Casey, she said, the department inspected abortion facilities annually. Yet when Governor Tom Ridge came in, attorneys interpreted the same regulations that had permitted annual inspections for years to no longer authorize those inspections. Then only complaint-driven inspections supposedly were authorized. Stolosky said that DOH's policy during Governor Ridge's administration was motivated by a desire to not be putting a barrier up to women seeking abortions. Brody confirmed some of what Stolosky told the grand jury. He described a meeting of high-level government officials in 1999 at which a decision was made not to accept a recommendation to reinstate regular inspections of abortion clinics. The reasoning, as Brody recalled, was there was a concern that if they did routine inspections, they might find that a lot of these facilities didn't meet the standards for getting patients out by stretcher or wheelchair in an emergency, and then there would be less abortion facilities, less access to women to have an abortion. The position of DOH remained the same after Edward Rendell became governor. Stolosky left them unmonitored, presumably with the knowledge and blessing of her bosses, Deputy Secretary Stacy Mitchell, and a succession of secretaries of health. The department continued its do-nothing policy until 2010, when the media surrounding the raid of the Gosnell Clinic exposed the results of years of hands-off oversight. Even if Stolosky was instructed not to conduct regular annual inspections, that does not explain why she failed to order inspections when complaints were received. It is clear to us that she was made aware numerous times that serious incidents had occurred at Gosnell's clinic. These incidents, which evidenced alarming as well as illegal long-standing patterns of behavior, warranted investigation. Yet in all the years she worked at the department, Stolosky never ordered even one inspection. On November 29, 2009, Gosnell sent a fax to the department, followed by a letter addressed to Stolosky, notifying DOH that Karnamaya Mangar had died following an abortion at his clinic, that he filed it late. Darlene Augustine, a registered nurse and quality health administrator in the department's Division of Home Health, received the fax. Augustine testified that she immediately notified her boss, Cynthia Boyne. Augustine said she told Boyne on November 25th that DOH should immediately go out to the clinic and initiate an investigation. Augustine acknowledged that she generally had authority to send surveyors out to investigate, and she often did so within an hour of receiving a notice of a serious event such as a death. She testified, however, that she felt she needed Director Boyne's approval because Gosnell's notice involved an abortion clinic. Boyne did not give her approval. Instead, she went to the Bureau Director, Stolosky, to discuss the matter. Augustine explained that abortion clinics were treated differently from other medical facilities because Stolosky had for years overseen the department's handling of complaints and inspections, or lack of inspections, relating to abortion clinics. Stolosky, according to Augustine, was the ultimate decision maker with respect to whether DOH would conduct an inspection or investigation. Augustine testified that neither Boyne nor Stolosky ever gave her approval to conduct the investigation she thought was appropriate. Stolosky, according to Boyne, was only interested in making sure that Gosnell filed an online report in accordance with the 2002 law, the Medical Care Availability and Reduction of Error Act. Stolosky's plan, Boyne said, was to then charge Gosnell with failing to file the report in a timely manner. Gosnell had reported Mrs. Mangar's death to DOH on November 24, 2009. While this was 3 or 4 days late and the notification came by fax and letter rather than computer, it is preposterous to think that Stolosky, who had ignored 2 deaths and other serious injuries at the clinic, would take action against a doctor for filing a report 3 days late. Appallingly, the chief counsel for the Department of Health, Christine Dutton, defended Stolosky's inaction following Mrs. Mangar's death. Dutton testified that she had reviewed the emails and documents showing that Stolosky and her staff were communicating with Gosnell's office to get him to file the MCARE form. Based on these very minimal efforts, Dutton insisted, we were responsive. Pushed as to whether the death of a woman following abortion should have prompted more action, perhaps an investigation or a report to law enforcement, Dutton argued that there was no reason to think the death was suspicious. People die, she said. Not only was a probe into Mrs. Mangar's death authorized and appropriate, it was required under the MCARE law. Yet DOH did not investigate. Instead of conducting an investigation, Stolosky and Boyne concerned themselves with badgering Gosnell to re-notify them of Mrs. Mangar's death. Bureau Director Stolosky, in fact, readily acknowledged many deficiencies in DOH's and her own oversight of abortion facilities. But her dismissive demeanor indicated to us that she did not really understand or care about the devastating impact that the department's neglect had on the women whom Gosnell treated in his filthy, dangerous clinic. When DOH inspectors finally entered Gosnell's clinic in February 2010, not at Stolosky's direction, but at the urging of law enforcement, Stolosky seemed more annoyed than appalled or embarrassed. Stolosky, the woman most directly responsible for the department's oversight of abortion facilities, told the grand jury, quote, I haven't been in an abortion facility in many, many years. It was not until February 18, 2010, when DOH representatives were escorted in by law enforcement agencies that they finally inspected the clinic that they had not bothered to visit in 13 years. And then they have a list of required things for if you put somebody under general anesthesia. The only items on the list that were in the facility in any form were suction and oxygen sources and an unusable monitor, defibrillator, and ECG. There was only one suction source for each procedure room, meaning that the same suction source used to perform the abortion would have to be used to resuscitate patients. The DOH document noted, moreover, that neither suction machine had an inspection sticker to indicate that it was functioning properly. The suction tubing on both machines were corroded. One oxygen source was an E-cylinder oxygen tank that lacked a label to indicate whether the tank was full or empty. The oxygen mask and tubing hanging from the tank were covered in a thick gray layer of a substance that appeared to be dust. The other oxygen source at the facility was an oxygen concentrator covered with a thin layer of dust. The oxygen concentrator bore no inspection sticker and no evidence of inspection to ensure proper functioning. There was no oxygen mask or tubing with the oxygen concentrator. The DOH document stated that the monitor defibrillator and ECG not only had no inspection sticker, but was unusable because there were no electrodes to attach to the machine. Latasha Lewis testified that the machine had been broken for at least 6 years. Other violations detailed by DOH in March 2010 were the failure to have patients recovered in recovery monitored by a registered nurse or licensed practical nurse. The DOH document stated that the clinic violated Section 29.3314 of the abortion regulations by failing to have corridor doors and passages adequate in size and arrangement to allow a stretcher-borne patient to be moved from each procedure room and recovery room to a street-level exit. DOH noted that ambulance crews on February 18, 2010 had wanted to evacuate 2 patients from Gosnell's clinic on stretchers, but instead had to help them walk through the corridors. The situation was made even worse because the closest exit door to the street was padlocked shut and staff could not find the key. Many, if not all of the violations cited in the March 12, 2010 document had been present for nearly 2 decades. The violations had been apparent when DOH site reviewers, including Susan Mitchell and Janice Stolowski, inspected the facility in 1989, 1992, and 1993. Yet it was not until law enforcement discovered the horrendous conditions inside 3801 Lancaster Avenue that DOH took action to close the clinic. Darlene Augustin testified that she was instructed by senior attorneys for DOH, Kenneth Brody and James Steele, that she should not reveal anything about Karnamaya Mongar's death to law enforcement when she accompanied them on the raid in February 2010. Had DOH investigated Mrs. Mongar's death as it should have, and had it discovered, as it would have, that an unlicensed employee had administered the fatal anesthesia, it would have been incumbent on the department to report these criminal circumstances. So that is just the Department of Health and what they knew, what they did, and what they failed to do.